So welcome everyone who has joined us so far. We're just letting a few more people in at the moment. We're joined today by David Kemeny, who's going to be talking to us about witness statements in PI and ClinNeg. I think we've got a broad mix of PI and ClinNeg practitioners today, so we're going to try and target the talk at both practice areas, which I think works really well actually with this topic. So hopefully you'll all feel that your questions are being answered, but we do have a Q&A section at the bottom of the screen where you can pop in any questions that you have. If you put your questions in the Q&A section rather than the comments section, that will keep you anonymous. And when I read out the questions to David at the end of the talk, I will make sure that I anonymize the questions. So don't worry too much about that. Our talk today is being recorded and will be available at a later date on YouTube. So don't feel like you have to take too copious notes. David has also kindly agreed to share a copy of his slides via PDF. So again, don't worry too much about taking notes. Just listen and feel free to pop some questions in the Q&A box. So I think we're going to carry on letting a few more people in, but David, I don't know if you'd like to introduce yourself for the attendees today.
Yes, morning everybody, or good afternoon. My name is David Kemeny. I am a predominantly personal injury barrister based in 3PB's Bournemouth Annex. I did my pupillage from 2020 to 2021, so I've been a tenant and in practice for coming up to a year now. Originally, I did a mixture of all sorts of common law cases from crime to possession, but mostly now I just focus on PI. Looking to carve more of a practice area out into ClinNeg, but most of what I do at the moment is road traffic accidents and the like. So this talk may be somewhat skewed in that direction, but I'll hopefully make it accessible to everybody.
Thank you, that's wonderful. Yeah, so this is our first talk kicking off the Lunch and Learn webinar series that BLS are doing for 2022. It's quite a big program, and David has very kindly taken the first spot. Please, all of you, have a look at the agenda for the rest of the Lunch and Learn series, because there's a lot of interesting things there targeted specifically at junior lawyers. So what I'd probably like to say to you all today is no question is a silly question. We're all here as juniors. That's the purpose of this talk. You know, probably lots of you have lots and lots of experience, but this talk is really aimed at those who, you know, are still asking questions, learning a bit more, trying to hone their technique. I think everybody has quite a personal technique with witness statements, but this will inevitably vary case to case. So good to have a listen and think about whether you might do something differently in one of your cases after hearing David speak. So I think without much further ado, we should get going. Just a recap for any that have just recently joined. We are recording today's webinar. If you want to pop any questions in the Q&A box, that will keep it anonymous. We're circulating a copy of the slides afterwards, and yeah, just enjoy the talk. So I'll hand over to David now. Thank you.
All right, thanks. Just to follow on from that, I should say if there are any questions asked at the end that might need me to go and have a look at something in a bit more detail, I am, or especially if we run out of time, I'm happy to answer a few by email if people were to either email Claire or Rasheen. You know, we can deal with that in due course. Okay, so today's talk has been put together with a view to going all the way back to basics. I apologize in advance if I teach some of you how to suck eggs. It's not my intention, but really, I'm just looking for the broad basics and any sort of tips and tricks, particularly looking at this from the perspective of counsel on the other side of the line, how these witness statements actually end up getting deployed in court and how courts view them. So without further ado, this is, as I say, just an introduction. As I'm sure all of you will be aware by this point, witness statements can vary infinitely in their content, even when you just look at PI and clinical negligence issues. So what I'm just going to look at are a few examples of different types of statements and the sorts of things that you would want to make sure that you put in there. And as I've said, some general tips on what to do and what not to do. This is also a work in progress, this talk, so if there's any feedback or further questions, those are obviously welcome for next time I give this talk. So the structure of what I'm going to talk about today is, firstly, I'm pretty heavily focusing on the importance of a witness statement, why you are drafting it in the first place, because it's often the case where you can lose sight of that and then things start to unravel at a point where it's too late to do anything about them. I'll then go on to some, again, very back to basics, details about how to format witness statements, what to include and why, then go into types of witness statements, look at how the court deals with the witness statements, comparing that to how I would approach a witness statement, particularly an opposing lay witness, and then some do's and don'ts and a few examples of what I've been talking about. Hopefully there will then be some time for questions at the end. So why is a witness statement so important? First and foremost, always keep the overall purpose of a witness statement front and center in your mind. It's perhaps stating the obvious but it is easy to lose sight of the wood when looking at individual trees, I have found. So firstly, a witness statement is for observations and not argument. The asterisk there is obviously, if you were to provide a witness statement, for example, for an interim application, relief from sanctions, or specific disclosure or pre-accident disclosure, pre-action disclosure, that would include arguments as well. But even in those circumstances, the factual reasons behind the arguments you're making are still critical. So make sure it's there to show what you have heard, seen, felt in various cases, or observed through correspondence if relevant. Secondly, a witness statement contains your client's entire case, or it should. The paragraph here from Practice Direction 32, which will feature pretty heavily in this talk, it is the equivalent of the client standing up in court and reading out everything that he had put down on paper. The judge reads it beforehand to save time, but you have to bear in mind that this is their one and only opportunity to say what they need to say. So, sorry, just on that previous point, it should obviously document then every loss that you're seeking to claim for, every fact that's in dispute, every material observation, because if it's not there, it's not anywhere. So a witness statement is there to exhibit documents and put them all into their proper context. If you have any contemporary notes or manuscript documents from the time, say at the time of an accident or at the time of an investigation, well, explain what it relates to and why. If you have an item of financial loss that you're claiming for and you have the receipt to prove it, say it and show it. That's particularly important in cases requiring complex calculations, especially loss of earnings claims and care claims. If you have a calculation based on loss of earnings, it needs to actually be explained in a witness statement, as opposed to relying on counsel to do everything in submissions at the end. We are maybe wizards, but we're not that magical. If necessary, put any calculations like this into a schedule, which can be annexed to a witness statement. Formally, it should be remembered, standalone documents do not exist as far as the court's concerned. So if it's not in a witness statement, remember CPR Rule 33.6, specifically sub-rule 3. If you have a plan or a photograph or a model or similar sort of document, and you haven't put it into a witness statement, and an expert hasn't included it, or a witness doesn't actively draw it at trial and show the judge, if it pre-exists, or 1C there, if you haven't given a Civil Evidence Act notice, then under sub-rule 3, it shall not be receivable at trial unless you've given proper notice as set out below, or the court orders otherwise. So it is possible to exhibit something outside of witness statement, but really include it in a witness statement wherever possible, because there's simply no reason to be on the back foot unnecessarily. Another reason you have a witness statement is establishing your client's credibility. Now, as I've said, look at this as their sole opportunity to tell their story. The eliciting further evidence or bringing it out at trial or under cross-examination in particular, it is often far too late for it to do anything. If you get to trial and realize that there are errors in a witness statement, you can make amendments, and in certain circumstances, you can elicit further evidence in chief by asking a few points of clarification, but that's in the court's discretion. So don't rely on that. And it's certainly, if a client comes out with, if a witness brings out further brand new oral evidence at trial, it will raise questions about why it wasn't included before and lead to the obvious suggestion that they're making it up as they go along to try and bolster a weak case. Also, given that a witness statement is drafted and signed before trial, often months or years beforehand, it stands to reason that their recollection when they made the statement and they give their instructions is going to be far fresher than it is at trial. And that's often a question that we ask when pointing to inconsistencies. So fresh oral evidence given on the day of trial that wasn't given 2 months, 2 years beforehand when they had the opportunity to set out their case will often be given very little weight and may in fact count against them. So if things go wrong, firstly, there are possible for adverse factual findings and adverse inferences against the witness. The point to remember is the point of a witness statement is to convince the judge that your version of events is more likely than not. That's the standard of proof in civil cases. Any inconsistencies, however small, will start to affect your client's credibility, and it will start to place them on the back foot. So if you can avoid any of these, well, do so. Failure to discharge the burden of proof. Well, again, remember the adage, he or she who asserts must prove, and this is often something that we say in closing submissions. Claims without any supporting evidence, especially if that evidence is readily obtainable from a quick search of documents or going onto Google or Companies House or whatever it might be, they are likely to fail because it leads to the suggestion that, well, if it wasn't obtained, then it probably doesn't exist. So further, if you don't deal with any contested issues, if you don't address issues in dispute in that statement, then they're going to be decided against your client because you have no evidence to the contrary. And now if you put those two together, and if this might cause a case to collapse for want of evidence, and it comes down to the way in which a statement was drafted, there's always the possibility that this might lead to a claim against the firm. So best avoided at all costs, especially if it is avoidable. So what to take from that? Don't be afraid to involve counsel. I realize this is maybe a bit of a marketing call, but and I realize that solicitors have a lot on their plates and are dealing with lots of different issues at the same time. If you have a multi-track case, it is likely that you're going to involve counsel at a very early stage, assess prospects of success, further case management ideas, maybe even before a claim gets issued. So they may be involved right at the beginning. You may have also asked them to settle pleadings or a defense. So they will be already instructed and have an idea of what's going on. However, even if it's a fast track case, now a lot of the cases that I do on the fast track, I get the papers 3 days, maybe even a day or even a few hours before, sort of the night before trial. At that point, it's too late to do anything. But if you are drafting a witness statement, if you're in the middle of case management and you have got directions with a trial date, you know this is going to be in, say, 20 weeks' time. You know you've got 10 weeks to look at witness statements. If you speak to counsel's clerks and maybe get someone booked in, then you can, even without necessarily instructing them to do it themselves, for counsel to draft it, if it's relatively simple, you can still ask for a sense check. You know, are we going in the right direction? Is there anything else you might want to include? So a stitch in 9 saves time, as it were. So formatting a witness statement. This is going very much back to basics, so I'll go through it relatively quickly. You'll probably be aware of the requirements. Practice Direction 5A sets out the general requirements for court documents, paragraph 2.2. Practice Direction 32 deals with affidavits and witness statements. The main points to remember for witness statements, paragraphs 17 to 19, and I'll go into this in a bit more detail on the next slide. But as you can see here, do include a proper head note. Maybe stating the obvious, but it's often the case that you get parties' names missing, or the court missing, or it just hasn't been updated since pre-issue. Certainly make sure that it's all correct with the up-to-date information there. The 3.5 centimeter margin may seem like being a real stickler where it's not really relevant, but it is far better to take up an extra page or two in the court file of your witness statements than for a witness statement to be stretched to the edges of the page and very, very difficult to read quickly. Always remember that, and I'll come on to this in due course. The purpose is to make sure that the content is easily readable. Further points down there in the witness's own words, etc., I'm going to come on to in due course. So the next slide, this is a template that I use from precedent when drafting a witness statement. You'll see there's lots of bits in red there. I'll come on to why that's important in due course, but I'm sure you can guess. I won't go into all of the bits of this witness statement, but as a requirements are in Practice Direction 32, but points to draw out, paragraph 17.2, the top right-hand corner of the first page of a witness statement needs to contain all the identifying information for the court to know this is what this case relates to, just in case it ends up out of the court file and it can be refiled. A specific point to point out there is subparagraph 4. This is not simply to count the number of exhibits attached to a witness statement, but to properly identify them by initials and number of each exhibit. Again, if the documents get spread everywhere, you can find out where they relate to. And 5 and 6, the dates. If you have a statement which needs to be translated because it's originally in a foreign language, make sure you put that in and update it, because it's always going to be the case that you work on a witness statement like this in dribs and drabs. As you get more information, you start it, you come back in a few days. Make sure that you update those dates at the end when you send a final version to the client for signature. Make sure it's updated then. Other requirements of a witness statement in paragraph 19. Most of them are set out here in the digital age. Obviously, these the CPR was drafted before remote hearings and PDF bundles became the norm. So typed on one side of the page doesn't really make as much difference in a PDF. But ones to point out, again, the 3.5 centimeter margin is more useful than you might think. It also helps to make notes as you're going through. So please include that. The second point is all numbers, dates, etc. expressed in figures. This is counterintuitive and it's often forgotten. The instinct is to write everything in long form. I think, and there's a reason I think it's put into the CPR, it is easy to read in short form. It also takes up less room. But just remember, when you are copying dates, especially if you have a lot of them, to get the dates right. I've seen on many, many occasions how a 2022 is in fact a 2020 and it just doesn't get updated, or there's a mistype. So do take real care with dates in particular. The next point is how to reference exhibits. The CPR actually specifies that you should put them in bold in the body of the witness statement. It does just, again, make it much easier for the judge to quickly jump to what they need to know. And it also helps when you're at trial and going back through a witness statement to be able to find it easily on the page. So please remember that. The final point though on here, and this can't be stressed enough, is that a witness statement should be drafted in the witness's own language. This does not mean, I would say, just in English or a foreign language, but it could mean, and I urge you to err on the side of caution, that you write it in their parlance as well. If you have a look at paragraph 2 of the example statement that I've got there, the second sentence, I make this witness statement from facts and matters within my own knowledge. Now, if you write a witness statement in legalese or include pieces of information that are ascertainable readily from your file, but aren't necessarily within the witness's knowledge, then the judge is going to be less and less convinced this is actually the witness's evidence. Similarly, if you write it, for example, that I wish to draw to the attention of this honourable court at the beginning of every paragraph, it isn't going to sound like the witness. So try as best you can to reflect their way of speaking. And if you've got it in an email from them, then copy as much across as you can, obviously taking care when copying information. Oh, and just to say, if you use headings, you don't need to use them all the time. If thematically required, and usually in clinical negligence cases, this is more the case, then use them, but use them sparingly. So there. The next points are to do with amendments and alterations. This is at paragraph 22 of the practice direction. If there are any changes, they have to be initialed by the person making the statement or authorized person where appropriate. If you do not, then the court may decide not to use that evidence at all because you can't rely on the statement as being authentic. So in general, just try and get it right the first time. If you are drafting various versions of a witness statement and updating it as you go, we'll just make sure it is absolutely the correct version before it gets signed. Don't rely necessarily on counsel being able to correct it when we get to court. As I've said before, if you correct too much, then it undermines the credibility of the original statement. And certainly it raises questions as to why it was signed if there was so much wrong with it. And it probably obvious, but absolutely don't just do it yourself. If it is the client's evidence, get the client to initial it. Just avoid any unnecessary headaches as much as you can. The next point is to do with translations, conveniently called filing of witness statements in the practice direction. Remember, firstly, it is in the client's own language. So that means if a statement is not, if English is not the client's first language, write it originally in the client's own language so that they can understand exactly what they're saying. Obviously, get someone who speaks that language to take the statement in the first place. But it has to be translated into English so that there is an identical copy, so the court is satisfied that they are looking at exactly the same document in English as the client understands in their own language. And that means a translator has to review it and put in a statement of truth that the statement is accurate. For good measure, I would have the client sign both versions of the statement, but only once they have confirmed that they understand their evidence. Otherwise, as you may expect, you will have the inevitable questions. Well, how did you know what you were signing if you can't read this statement? How are you able to confirm that the contents of your statement are true and accurate to the best of your knowledge and belief? I have seen this happen in court and the case collapses. So it is very, very important to remember. So the witness has to understand their own evidence. The court has to understand the evidence. So we need an English version as well. And it must be reliable. So if the witness can't confirm it, it isn't reliable. Now, if things go wrong, and there are defects, there are things that don't conform to Part 32 and by extension Practice Direction 32, the ultimate sanction is the court can simply refuse to admit it in evidence. It's the same if you amend a statement and don't initial it. Potentially more importantly for the firm, the court can also refuse to award any costs associated with preparing a statement, so outgo your billable hours. If you have made a mistake, you can get the court's permission to correct a defective statement. Do seek counsel's advice as well if you need a sense check, because it's better to get ahead of these issues before they actually cause a problem. All right, now turning to common types of witness statements. This is obviously with a specific focus on PI and clinical negligence disputes. These are all variations of the same idea. In large part, their content will obviously vary from case to case. Now, sometimes you have liability and quantum statements together, but in more complex cases, say multi-track cases, where there's a split trial, or if liability or quantum have been admitted, you'll just get that instead. So looking here at liability statements, in road traffic accidents, you will obviously want to understand what the client remembers about the route that they took, how they got to the place of the accident. What was the time of day? What were the weather conditions? What was the lighting like? All of this speaks to whether or not someone breached their duty of care. What care should have been taken in the first place? It's all background circumstances that speak to the central issue. At the road layout, that needs to be spelled out in enough detail for the judge to be able to visualize it, because you are effectively trying to get the judge to imagine what happened. What speed you were traveling, well, certainly don't assume anything and don't put words into your client's mouth, but as much as possible, try to get any records of when they checked the speedometer at what point and why they know that, put it in. Simply asserting, oh, I was going 30 miles an hour. And if you get to trial and say, well, I was probably going 30 miles an hour. Well, I think I was going 30 miles an hour. Well, I was going 35 beforehand and I slowed down a bit. All of a sudden, they stop being credible. So get that as much detail as you can and pin it to objective evidence if you can. Now, maneuvers doesn't just include someone turning left, someone turning right, but also indicating. Again, make sure you ask these questions when you're originally taking client instructions, because if it comes out at trial but isn't in the witness statement, it doesn't help you at all. And then observations, these are common to all of them. What you heard, what you saw, what you felt, what you remember. It's all about your visual and sensory experiences. That's what the court wants to know from this, for this witness, not their opinions, not any suppositions. I had one recently where a client gave a very lengthy and complicated calculation of the angle of the sun in the sky and therefore how that would have reduced someone's visibility, but it was self-evidently not in the client's own words. It seemed to have been something that was done using weather data, but even that wasn't exhibited, so we just didn't know where it came from. Employers' liability cases. What task were they doing and why? This is all going to go back to the pleadings again. What was their prior experience of doing that task? What was the training that they were provided? All of this speaks to the employer's liability or otherwise, if something goes wrong. Again, what PPE they were provided for. What the witness, not what the documents show, but what the witness understands about the risk assessments and method statements that were carried out, particularly in construction work. It's very important. If the client isn't aware of them, but there were some, well, it can be dealt with through other evidence. And again, what they heard, saw, remembered, etc. Public liability claims are a mixture of everything. In addition to what we've said above, you would want to look for any inspection regimes, especially if you're acting for the defendant, not just here is a checklist of people's signatures, but if you can provide more information about what those inspections contained, as much detail as you can, it avoids having to shore up missing evidence at trial. Similarly, any warnings given, signs or otherwise, very important to put them in if you're for the claimant, when you saw what you saw, if you're for the defendant, when you placed these warnings. Seems simple, but easily forgotten. And then in clinical negligence claims, these are going to be naturally, I think, more complicated in terms of their chronology and background, but do include any previous medical history. Go into detail about the presenting complaint, when it was noticed, how it was noticed, when it was reported, details of the investigation, particularly if you're the defendant, but even if you're the claimant, what you were told about the investigation at what points, because even a claimant's understanding of what they were being treated with is also going to be important. And then in the aftermath, how symptoms progressed and how they were noticed, how they were reported, etc. After the event is also going to be relevant for quantum. The point of these is obviously to show if a breach occurred for the claimant at one stage or another, and the earlier it happened, the greater the avoidable and thus recoverable loss. So as detailed a chronology as you can put in would be very, very helpful. Now, as for quantum, general damages claims will obviously go into the type of injury that you're claiming for, but also detail when the symptoms were at their worst, what point they improved. If you can tie this to a specific point in time, such as when I went back to work or by my birthday, put it in, because the judge is going to want to decide, well, when did symptoms improve, by what point? Any changing loss of amenity, try and document that as much detail as possible, and don't, as I've seen, don't just take what the medical legal report says and put it into longer sentences, because it may be that the doctor hasn't gone into as much detail as they should have done, although at that point, really, you want to have checked the contents of the medical report before disclosing it, compared it to the claims notification form, compared it to your instructions, and if there is anything missing, going back at that point. Sometimes you might get to a stage where it's too late to perfect the evidence, but check it every stage. Now, as for special damages, as I say, tie it to the evidence. If you have parking or medication receipts, try to get them included, exhibit them in the witness statement. Obviously, it's not just physiotherapy invoices. If you have mileage, and this comes up quite a lot in, say, stage 3 hearings, which are very quick quantum assessment hearings, if you can show that the client traveled from A to B, and by going into Google and putting it into directions, which shows the number of miles, it's easily done, and it will save a lot of argument, and a lot of judges are more likely to wave that through. Now, care claims they really have to be given a lot more attention to detail than anything else, I would say. This is because minor differences in how much care is required on a day-to-day basis can multiply significantly in future loss cases. If you're looking at lifetime care or even care for several years, the difference of an hour a day can be thousands or tens of thousands of pounds. So if you can take precise instructions, for example, gardening is often one that crops up. You can make a claim for 2 hours a day in a schedule of loss. Without more, a judge might say, I'll give you half an hour and that's it. But if you can say in a witness statement, this is how I would tend to my garden, this is the size of my garden, this is realistically how long it takes, this is the help that I would get. Again, it just gives you more ammunition. It gives counsel more ammunition at trial to say that this is a reasonable assessment. So compare with the schedule of loss. Don't overplay your hand, but do be realistic when going to this, and try and get as much in at the witness statement stage as you can. Now, a few other statements that you're likely to come across in practice. Eyewitnesses. Do remember there is no property in a witness. So if your client mentions in a medical report, I had a passenger with me in the front seat, and they haven't provided a witness statement, the court is going to want to know why, and opposing counsel is almost certainly going to suggest that they didn't give a witness statement because it's not helpful to your case. Often they are more harmful by their absence than they might be helpful by their inclusion, but don't ignore eyewitnesses, and try as much as you possibly can to get as much evidence from them as possible. Now, if you obtain a statement and they are truly adverse to your claim, in a small claim, disclosure rules don't require you to disclose it. In a fast track, they would. So at that point, keep an eye on your prospects of success, and if necessary, reconsider your position as you go along. Don't just use them as extra ammunition without thinking further. Fee earners. So these would be statements that you provide, typically for interim applications such as relief from sanctions and disclosure. I touched upon this earlier on. They will include legal arguments as well as factual observations, but don't forget the factual background. If there is a long history of irritating case management from the other side refusing to cooperate, and there are emails to show it, we'll exhibit those, because it will bolster your arguments that the relief that you're seeking to get is just and proportionate. In relief from sanctions applications in particular, hopefully you will know the case of Denton and T.H. White, which sets out the 3-stage test. I've seen statements which wildly overplay the it's not serious and not significant card. You'll start to undermine your credibility at that point if failure to pay a court fee or failure to follow case management directions you say is not really significant. So approach them with care, and if necessary, focus on all the circumstances, because that's usually what we end up doing in the hearing. BHR evidence, I won't go into this in any detail because it's a whole credit hire as a subject in and of itself. But just to say, these I've come across a lot in credit hire practice, and these are fraught with difficulty, because if the defendant does not show that a comparative rate is truly comparable, then the court will default to a credit hire rate. So they are often all or nothing, and they're often put together by people potentially without any legal experience, certainly who aren't members of the firm. They are separate companies. And so these really need to be double checked and triple checked before including them in litigation. Finally, litigation friend statements. So any claim for or on behalf of the child or against the child will need to go before a court for approval of a settlement. If you want to deduct any money through a CFA, you have to comply with the requirements of Practice Direction 21. 11.2 and 11.3 go into a lot of detail prescribing what you need to do. In particular, risk assessments. If you conduct a CFA and you simply say it's 100% success fee because it's a very risky case, but it's a child where liability is admitted, the court isn't going to take that seriously either. So be realistic about your risk assessments if you can. Right, turning to the court's approach. Firstly and foremost, the court is looking for common sense outcomes. And this is truer the further down the hierarchy you go, for reasons I'll explain. But remember that the standard of proof in these cases is the balance of probabilities. And it's trite to say, but that doesn't just cover what facts you are able to explicitly prove, either through objective evidence or detailing them in your witness statement. But by default, the court is also going to consider which version of events is inherently more likely than the other. And it's often an argument that we bring out in submissions. So bear in mind, if your argument is more unusual version of events, recognize the hill that you have to climb and approach it with caution with due care and attention. So the court is looking for reliability in its witnesses. That is not just, it includes this inherent likelihood point, but it also includes the demeanor of the witnesses as they give their evidence and comparing what they say with any objective evidence. So there is a real need to stress test your client's version of events. I appreciate if you're acting on behalf of a client, you are going to want to believe them, but do be critical about the information that they're giving you and see if it actually stands up to scrutiny, because you can bet your fee on the fact that the opposing counsel will do exactly that. The court is looking for ease of reading, and this is much more significant than you might think. It goes back to the formatting points I say earlier, but given the volume of work that judges have to get through, the speed at which they're going to read this witness statement, the right information needs to pop out to the judge, as well as containing all the information for counsel. So what I would do, and if you take anything away from this, what I would recommend is imagine the judge has to do a visual walkthrough in their mind's eye of your client's version of events. This is particularly the case in road traffic accidents, but any PI claim, I would think. It is your evidence is always going to be most effective if the judge can effectively go through the incident frame by frame in slow motion just before the moment that you allege a breach of duty. And especially in a road traffic accident case where everything happens in a split second, this is particularly important when you are doing 3 different maneuvers at the same time, looking in various directions and traveling at speed. So whenever I prepare this, and I'll go into this in due course, I always try and step by step, as though I'm in street view, inching forward frame by frame to take this into account. If you're describing locations on the road or in the workplace, wherever it might be, set the overall scene explain how all of the different locations link up, use plans if possible. And for example, if you're approaching a roundabout and there are 3 exits, we'll say there are 3 exits from where I was approaching. The first is at 8 o'clock, the next is at 12 o'clock, and the third exit is at 3 o'clock, so that the judge can then look at the plan and go, ah, yes, I see exactly where you are. Because it can take 20 to 25 minutes sometimes at the beginning of a cross-examination just to orientate the judge as to where the different parties were coming from and why. If that's set out in witness statements, they will definitely look at your evidence more favorably, I would think. So don't just rely on a map. If you can, tie it into the statement and explain it. The counsel will be doing this anyway, but if you can front load this work, it will certainly help. If you have any identifying features on the road, for example, and I said this is mainly RTA focused, but if you have street signs, bins, curious trees, whatever it might be, the claimant, usually in this case, but the driver, can remember and therefore orientate themselves in space and time at a particular point, it's going to be extremely useful for the judge, especially if they can also see it on the street view. So this helps to give the judge a sense of time, because if it takes X number of seconds to go from A to B, and you're alleging all of this, these actions happen in that space of time, and a reaction needs to happen in that space of time, it will all be very relevant to, and it could make all the difference when the judge considers reaction times and the reasonableness of reactions in various situations. If you struggle to follow an account like this, there is a very good chance the judge is going to struggle as well. Clear cross-referencing, again, I've dealt with that before. Just make it easy for the judge so that they can flip between your witness statement and the exhibits and back again, because they really won't have very much time. Points to remember on this: courts have extremely busy lists, sometimes 5 to 10 cases in a day. The court will just have read the statements prior to trial, sometimes just the pleadings and the statements. Any supporting documents they will only really consider, especially in busier lists, if they're specifically taken to them either by a witness statement or by counsel. So poor presentation in this has a huge impact, and ease of reading really is critical. Secondly, we can't give evidence. All we can do is highlight what the witness has said. If the witness hasn't said it, counsel can't fill in the gaps. We may be able to elicit a few points of clarification in chief. This is in the court's discretion, I said, and it is distinct from advancing entirely new allegations and entirely new sets of facts, because as I've said, that's fresh oral evidence, and it will be given very short shrift. So submissions are for saying what he or she means is, but this must be based on the evidence that's already before the court. We can't invent anything. It's very difficult to recover a lost audience, so you want to keep the judge on side as much as possible, because once they look upon your case or your witness's character or the credibility of your arguments or your legal team, depending on the situation, with disfavor, it's very difficult to win that back. Finally, as a separate point, the court, depending on the court, they often print out the relevant documents, and they usually print it out in black and white. If you're preparing a witness statement with plans and in the exhibits and different coloured arrows, it's often best to number them as well or use shading, because particularly if you photocopy documents over and over again and they're also in black and white, then the quality is degraded to the point that they're just not useful. All right, so counsel's approach, realise I'm a bit pressed for time. Firstly, whereas the court looks to understand the client's evidence, counsel looks to undermine it. That's the whole point of our job. So first, we give it a methodical read through 3 times. Firstly, we get the gist of what the client is saying. It actually applies for the whole case. Secondly, we'll then pull out key points and lines of attack. And then thirdly, read it again to prepare our cross-examination. So if counsel's doing their job right, any inconsistencies are going to be noticed. I certainly try to visualize something, say Google Maps, as much as possible. We'll also then compare it with other evidence as you go through second and third stages. So where do the facts and the pleadings differ from the other side's case? We'll read the witness statements with the pleadings in front of us, because we need to, at the end, we need to make sure, what are we trying to argue? and bring everything back to that point. What does the other objective evidence say in the bundle? Well, if there's a conflict with the medical evidence or engineering evidence compared with what the witness says, you can be sure that we're going to bring it out and use it to thwack your client with them. I certainly use common sense sources as well, even if they're not in the bundle, but bear in mind, if they're not included in the bundle, then the witness can't be taken to them. You can't really ask them about it. It's mainly just for counsel's understanding. Highway code is certainly useful, and I've had cases where the relevant parts of the highway code were placed in the bundle, and it was much more helpful to take the witness to them and undermine their case than simply arguing it, because in all likelihood, lay clients won't have read the highway code, even though we're all supposed to have done. Right, and then when preparing for cross-examination, the first thing we do is start with our closing submissions. Certainly this is the way that I've been taught to do it. What needs to be argued at the end? What evidence needs to be elicited from the witness in order to get me there? And then we start to reverse engineer it. And at every stage, we are looking to undermine the credibility of opposing witnesses. And this is always front and center. So the tricks that we usually use, we'll look for inconsistencies. Now, they could be within the document itself, within the witness statement. They could just be minor spelling errors, but they'll certainly be brought out as an evidence of carelessness. Unnecessary errors, such as saying, I turned right, when quite clearly the evidence shows you turned left, even if you correct it at trial, or rather, if you don't correct it in chief, we'll certainly use it to say, you sure you knew where you were going? Then you get onto the more significant ones. Incomplete sentences. I've seen them happen. They should be easy to spot, but somehow these statements go to trial. That undermines the reliability of the client, because they're supposed to have read it carefully. And then paradoxes, quite clearly, if the client says one thing at one point and objective evidence quite clearly shows the opposite, then you're in real trouble. And this is the sort of thing that needs to be spotted when statements are being drafted, as opposed to hoping counsel doesn't see it at trial. We'll then also look back to the pleadings and say, well, you've actually alleged X, Y, Z, and in your witness statement, you're not saying it, or rather you're saying something different now. And objective evidence and what other witnesses say will obviously be brought in to say, well, can you really be sure of what you're saying when someone else is saying something different, especially if they're your witness as well. All right, I recommend that you can ignore the red circle for a moment. That's just an error with animation. Firstly, construct the narrative. Secondly, then compile the evidence and then proofread. So as always, keep why you are doing this witness statement in your mind when you're drafting it. It should be pleadings driven and not client driven. Obviously, the client's version of events is very important, but I would say you need to remember what you're trying to prove and then build the evidence, the narrative around that, as opposed to simply getting a train of thought from the client. That latter point is important for getting the whole story and stress testing. If counsel is going to do it at trial, you want to make sure they don't have an absolute home run when you get there. So when the client says, well, I was traveling at 40 miles an hour, and it took me 4 seconds to get to this point. I was about 170 meters away. I had this recently. Well, that's about 95 miles an hour. So double check the maths, especially if you're going to be looking at calculating time and distance. Then when you compile the evidence, get as high quality evidence as you possibly can. It shouldn't be necessary to print screen or especially take a photograph of what's on your computer screen. You can print screen, you can you save images from Google Street View, etc. It should be very easy to get and in high quality. Especially if you've got Street View, make sure that you can see the lanes, because I've seen cases come to trial where you simply can't see what this image is supposed to see. They then can't be used, so there was no point getting them in the first place. And then, as I've said, if there's relevant evidence that goes to why you're saying what you're saying, exhibit it properly and point the court to it. Finally, proofreading, and this is where the circle comes in. This is a very handy feature that I use in every piece of drafting that I do. If it's a witness statement, particulars of claim, skeleton argument, I use the read aloud feature and it just reads it back to you. It makes it much easier to hear where a sentence doesn't quite make sense or suddenly you're calling your male client she because you've copied it from something else. Now we come to the red text. The example that I gave before had a lot in red text. If you make any changes to a statement, just err on the side of caution, turn everything red again, make the changes until you're sure that it is accurate, and then change it back to black. Otherwise, especially with longer statements, it's very easy to lose track of the changes that you're making, and then these errors come up. That should be covered to some extent by the read aloud feature and having someone else having a look at it. But certainly by the end, the client really needs to know they can't look at a witness statement in a minute and sign off on it and send it back to you. They need to actually read it properly. Otherwise, the court will know. Things to avoid. I'll skip through these quite quickly, but mainly write with your client's version of events in your client's words. Don't put words in their mouth. Don't make assumptions, even if you would think it's obvious. Take your client to it, ask them about it. If they say, oh yeah, actually that does make sense, then you can put it in your statement. But otherwise, if you have put something into your witness statement and then counsel asks about it, they won't have any knowledge of that going into their statement. They probably won't have read it if you haven't stressed it properly, and then they'll resolve from their statement completely. And then all of a sudden your credibility is shot. Certainly don't use the same statement for several witnesses, even if they're going to be saying the same thing. It very easily comes out at trial that it's not any of their language, and is often fatal to a case. Work in good time, seek counsel's advice wherever you can, or when you need it, and don't leave it to the last minute. Right, just a few examples, very briefly. I realise I'm running over slightly. This is a part of a witness statement from an RTA case I did earlier this year. A bus company was the defendant and the claimant was a passenger who fell when the bus braked too sharply. The defence was simply, we have no knowledge of this accident whatsoever. We've asked all of our bus drivers. They don't remember this accident whatsoever. What can we tell you? The defendant's evidence was 4 statements from different drivers who all serviced the route at the same, during the material time who it possibly could have been. 2 of them left the company and their evidence was hearsay and ignored, and 2 of the drivers showed up at trial. Driver 1 statements on the left, driver's 2 statements on the right. They are almost identical. The only thing that really changes between them is the bus number, the fleet number, and the time that they serviced the bus stop. But each of them says at paragraph 12, I can see from ticketer tracking information that I served this bus stop. When I asked the drivers what the ticketer information meant, they looked at it and had never seen it before. This is particularly important when paragraph 1 of their statement said, this statement is made from matters and information within my knowledge and belief. And all of a sudden, the defendant's evidence was, the credibility was completely shot, and the claim was allowed in full. Second example as to remembering why you're making the statement. This is an engineering report. I'm not sure if anyone can spot the issue here. It's here. The point of the statement is to prove negligence. Negligence requires 3 things: the existence of a duty of care, breach of that duty of care through the accident, but also that it caused loss. If the I think this was the claimant's vehicle, suffered no damage because it wasn't worth anything to start with, then the case failed. And that's exactly what happened. Third point, very briefly, if you have a statement in another language, make sure the court can understand it. This was a statement that the court had that apparently the client signed, although there were other issues there. There was an English language statement that purportedly was the same thing, but no certificate of translation, no real certification that it actually said the same thing. And so that wasn't treated with very much weight. The final example I'd like to show you is the importance of taking instructions carefully. This was a road traffic accident on a crossroads. I was for the defendant. The key issue at the trial, or one of the key issues as to liability, was who ran the red light. and so who crossed when they shouldn't have done. Now, the image on the left is a plan that we had showing the parties' direction of travel. The image on the right is a picture taken at the time. Now, my client's evidence, as I say, was for the defendant, was that she travelled through the area where all the roadworks were. The problem is, this building in the background behind the roadworks is this building here on the bottom right. And a street view made that very obvious within the first 2 minutes. The problem was, her evidence was that she was travelling this way down, when in fact, she was travelling this way. When I got to 9 a.m. on the day of trial, having been given the documents very briefly beforehand, I took her through this and said, there seems to be a bit of a disconnect. Where do we go from here? And she said, oh, actually, no, I was traveling, as I've now shown, the claimant was traveling east to west. So in effect, we were then agreeing with exactly what the claimant had been saying about the party's direction of travel. This completely undermined her credibility. So the point of who ran the red light, which would have been determinative of the trial, it almost became a non-starter, because we then couldn't rely on any of our evidence about it was definitely this direction that I was traveling and I saw this way and that way. So do make sure that you get that right, otherwise cases can collapse. So very, very briefly, I'll open all of these now. Do remember why you're doing the statement and keep that in mind. Don't just follow a formula. Do stress test the evidence, but don't tell the witness what to say, obviously. Include everything that needs to be included. It seems obvious to say, but it's often forgotten. Don't just rely on counsel to adduce it and perfect that evidence at trial, because we can only do so much, professionally speaking. Do write it from the witness's perspective, as opposed to just getting them to check and sign a completed statement that they will then not be able to actually support when cross-examined. So review your drafts carefully, and stress to the client that they really need to read it carefully. If they read it in 30 seconds and come back to you and say, yes, that's fine, don't be surprised if you get to trial and they say, oh, I didn't write that bit, my solicitor wrote that bit, I don't remember that bit, and then all of a sudden the case collapses. And again, don't make legal submissions unless it's a fee earner statement and you're actually making legal arguments, as opposed to a lay client statement. Finally, small claims are often forgotten. I know you do them very, very quickly, but don't cut corners, because small claims add up. And often they fall apart just because the witness evidence just doesn't make sense. So if need be, sense check with counsel. We're always happy to help, even if it's informally, because it will save us a headache at 3 in the morning when we're trying to read through the statements. And if it's a particularly complex one, we're often more cost effective than using your billable hours to draft a statement. So thank you very much for listening. That's everything. We have a few minutes for questions, I think.
Yeah, thank you, David. We've allowed a couple of minutes for questions, but we don't have any at the moment. So if anyone has any, you can type them in the Q&A box now, or email them afterwards, and we should be able to follow up with David then. So I thought that was very useful. Thank you. I have been to court with a witness statement that I've drafted, and I've seen the sort of cross-examination that the witness goes under, and yeah, it's terrifying. If you drafted the statement, it's a moment where you just think, come on, this is what you told me. Please repeat it exactly as you told me. So yes, stress testing, really good point. I don't think it is apparent until you've been to trial with a witness statement that you've drafted, because you're sort of drafting them all the time. And it's very rare that we in PI go to trial, and potentially the same with Clin Neg as well.
Especially with fixed costs as they are, it's a lot less likely that fee earners are going to attend, especially fast track cases, and certainly not small claims track cases. So until it becomes really, really significant, it's possible that you won't have actually seen how they're deployed. So if you can, if you can not sneak out, or at least get dispensation to go, it's certainly worth watching how they get used at trial. I had one a little while ago, a CFA case. I went up to Bath, and it was a case of fundamental dishonesty against my clients, and once we got through the first claimant, it was multiple people in a car. There was a lot of, well, I can't really recall that. I can't really recall that. I don't really remember that. Well, you waited 9 months before you did anything. Well, I didn't realize I needed to. Well, where did you realize you needed to? Oh, well, my solicitors told me I could. And then you start to open up some professional regulation issues there as well. And then by the time we got to the second statement, she said, I don't remember ever looking at the statement. I can't remember anything. I didn't look at the medical report. I don't remember anything to not tie herself then to the evidence that she's going to give. We managed to avoid fundamental dishonesty, but certainly the case collapsed. There was no way that it could go forward. So if you can see it in action, it's definitely worth doing so.
Yeah, I think that's really good advice. Yeah, well, fantastic. I found that very useful. I hope that everybody else did.
Yeah.
I am aware that we're sort of reaching the end of the allotted time now, and we've not got any Q&As. But please do follow up if you do have a question afterwards. David, your email address, perhaps we can circulate that with your slides later on.
Oh, yes. Sorry.
Yeah.
There we are.
There we go. Yep. So if you just want to screenshot the page, if you've got any questions that you want to follow up with David, then please do. And as I said, we're looking to get this up on YouTube, possibly towards the end of this week or early next week, and circulate a copy of the PDF slides as well. So thank you very much all for attending. You've had David's input today. It's been wonderful, really helpful. And we've got the rest of the Lunch and Learn series coming up. So please have a look at the Law Society website or an email that you may have reached you already to see what else is coming up. But yes, thank you very much for attending. Bye, everyone. David, if you just want to hold on for a few minutes.